Alex here with part 218 of the My Docket series on child custody and visitation. As my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my exit parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. Mindset is obviously going to be very good at this point. I have gotten the decision of the district judge reversed, and basically the motion for costs that I'm about to file is for sure going to get granted. I just couldn't visualize or envision a scene where she would deny this motion right after the Court of Appeals reversed the last one. That would be so blatant that even the Commission on Judicial Discipline might have stepped in. But none of that happened. She does grant the motion that I'm about to go over, and that, of course, is going to award the $250 in costs that she refused and an additional $250 in costs for the second appeal. All that being said, I think we should just go straight into what I have filed. Here we have the motion for costs on appeal. This is the second one that I filed. Standard introductory paragraph. I introduce myself to the court, indicate that I'm filing a motion for costs and that I'm appearing in proper person, which means I don't have an attorney. My summary here is that I have retained sole custody of our son. My ex's parental rights were terminated. This court committed reversible errors in tandem. Tandem means one after the other. And then I'm now seeking to obtain costs on the error as well as an award of costs associated with the second appeal. Factual background is that on January 26th, this court abused its discretion in imposing an attorney fee award in favor of my ex and against me. And then that this court took action on remand, vacating the erroneous attorney fee award, but abusing its discretion again in denying my motion for costs. Legal analysis. I am entitled to costs on the first appeal. The costs incurred for the appellate disposition by the first order reversing is basically going to be controlled by the decision of the Court of Appeals, and the court must award costs because the Court of Appeals said so. This court has no discretion. Accordingly, I'm requesting the court impose costs in the amount of $250. Next, we have an entitlement to costs on the second appeal. Now, for the second appeal, I can't use the order reversing because this one is it's a separate case, but I can use something called the law of the case doctrine. So first, I'm going to go ahead and cite all the same arguments that I cited last time, which is the rules of appellate procedure 39 sub C1 and 39 sub E, as well as statute 18.060. Those are the same statutes that I used last time, and then you can see that I'm once again citing Kiever v. Jewelry Mountain Mines, which is going to tell this court that the award of costs is clear, emphatic, and peremptory. But what I can use, and this is what I mentioned a second ago, is something known as the law of the case doctrine. And I have created a legal nuts and bolts video on the law of the case if you want to look at that video and take a look and learn a little bit more about how the law of the case works. But as you can see, in this case, Nevada State Engineer versus Eureka County, quote, where an appellate court deciding an appeal states a principle or rule of law necessary to the disposition, the principle or rule of law becomes the law of the case and must, not may, must be adhered to throughout its subsequent progress, both in the lower court and upon subsequent appeal, unquote. So I'm using this doctrine, which says that this issue is the same issue that was resolved by the Court of Appeals in the other case, and therefore you're bound by the same logical principles that they've applied in that case to this case. I filed a verified memorandum of costs concurrently with the instant motion. Previously, Department 11 of this court determined such a paper to be insufficient to support a basis for a cost award. but our Court of Appeals disagreed. This is the third order reversing. This is the one that District Court Judge Chuck Weller messed up on. And so once again, I'm using the law of the case for this disposition as well to force this judge to go ahead and apply the principles that the Court of Appeals applied to the fact that a verified memorandum of costs is enough to support an award of costs. Judgment. So for me to execute on a cost award, a judgment some certain is necessary, and I'm asking this court to merge the first cost award of $250 with the second cost award of $250 together with the cost taxed by the Supreme Court of Nevada of $5.04 into an enforceable judgment in the amount of $505.04. Mentioning here that there was some kind of issue with how the cost bond was released or filed or something like that with the original cost bond, the last one that the court said needed to be returned, and that basically no cost bond was filed this time, so there is no need for this court to return a second cost bond because there just never was one filed. What happened was they sent the first one to the wrong address, and then I called them, and then I asked them to send it to the correct one, and then there was an issue with that process. I guess they had to cancel it and refund it or something like that. So then I said, you know what, never mind, just count this towards my second appeal. Just keep this first bond and count it towards my second appeal. And so when I filed the second appeal, I just filed the $250 or paid the $250 filing fee, and I didn't bother with the cost bond. Then for some reason, a few months later, they returned that $500 anyway. So in any event, that's what I'm trying to go over here. The erroneous filing fee must be refunded. This here, I'm not sure. This here is a filing fee that the court collected. It was an additional $34 in fees. I'm not sure why they did this. At the time, I thought this was incorrect because it was some kind of issue with the eFlex system. It probably is incorrect, and I just didn't dig into it enough to try and get that $34 back. So in case anyone's wondering, the way eFlex works is you kind of go through a drop-down and click on a button to file something, and the way that they were handling filing fees for the Supreme Court just didn't work with that system, and I didn't know that they were dealing with them manually. So I ended up using this system. It charged me $34, and then they called me up and said they had to accept the $250 manually, and then I was like, can I get this $34 back? And I can't remember if I got the runaround or if they just never answered me. I was hoping that this judge would order this money refunded, but she doesn't, and in any event, I just let that go. Conclusion, I'm entitled to costs on appeal. Declaration. This is a declaration in lieu of affidavit where I'm swearing under penalty of perjury that the contents are true and correct. Rule 5 certificate of service indicating this document was mailed to my ex. Here we have a motion opposition notice, and according to these boxes, I think there is a filing fee. Is the motion change of filing? No filing fee, so I didn't have to pay the $25 filing fee. We have the list of exhibits indicating a receipt. And here is the receipt for the $34. Next, we have a memorandum of costs. This is me taxing my ex for $250 in costs. Rule 5 certificate of service indicating this document was mailed to my ex. Request for submission, and I am submitting this motion to the court for decision. My ex didn't file an opposition. If you want to know more about the request for submission, please watch my video on the topic. Request for submission. Rule 5 certificate of service indicating this document was mailed to my ex as well. Going into the aftermath, I filed 3 documents. They were all free filings, so I incurred $0 in costs. My ex didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex didn't have an attorney either, so she incurred $0 in attorney fees as well. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.